in your written evidence there's a serious risk of mistakes in terms of the EU dashboard. Have you, or has anyone to your knowledge, done a comprehensive audit of whether everything that's on that dashboard should be, and whether there are things that aren't on it that ought to be?
Thank you for that question. I think my starting point is no, we haven't. We are trying, as in UK and Changing Europe, we are trying to track the changes to retained EU law. But as we've seen from the FT reports this morning, the National Archives have worked with government and they've found an extra 1,400 pieces of retained EU law that they didn't seem to know about up until about last week. And so it looks like there's somewhere in the region of about 3,800 pieces of law. And if they have found an extra 1,400 pieces after the extensive work that government had done before that, it makes you wonder if there are other things that are out there. And this is the issue with the sunset being the default position, because as a default, it will turn off everything that is retained EU law, even if the government's unaware of what that retained EU law actually is.
Thank you.
Thank you. Well, thank you for that news. I wasn't aware there are another 1,400 pieces of legislation. I hope that they will be sending that information to the minister, if not the whole committee. I think that sort of highlights one of the concerns we have about this bill. You've made some recommendations in your report that the bill ought to make it clear which pieces of legislation are subject to the sunset clause, or they could actually exempt certain policy areas from that sunset clause. Could you just explain to the committee why you think that would be a good idea?
So on the first point, actually listing what are the relevant provisions that will be turned off, it avoids the situation of those bits of legislation that we don't know about, i.e. that they haven't been found despite an exhaustive search by now the National Archives, from being accidentally turned off, and we didn't know they'd been turned off until they become an issue down the line in some sort of litigation. So one way of avoiding the issue of avoiding error is to have a list of legislation, what looks like now 3,800 pieces of legislation which have been identified, and say these are the ones which are potentially subject to the sunset. And then once you've listed all of those, then in the statute, then it avoids the problem of those missed bits from being caught up by the sunset. And then in respect of, once you've done all of that, then you can say, right, what we should be doing is consulting on those bits of legislation. I'm not in any way advocating, as Stephen Law suggested, that we should be in a situation of stasis and do nothing. Quite the contrary. One of the reasons for Brexit was to think about how we can have laws which are more suitable for the United Kingdom. But the trouble is this slash and burn technique means that there's not proper consideration being given to what a future rulebook might look like.
Okay, thank you. Just one final question then. So obviously the vote to leave was over 6 years ago now. Do you think it would be reasonable for the government to be able to say which laws they intended to retain and remove by now?
Yeah, absolutely. I'm not in any way advocating that there should be no change, quite the contrary, but the trouble is this rather brutal approach that is envisaged by the sunset clause and the lack of clarity around how the delay process, so the provisions in clause 1.2 or clause 2 will be used, means that it generates huge amounts of uncertainty for users. And again, unlike Stephen Law, what I would say is that these laws cover things as fundamental as, for example, gas safety of equipment or food safety, what goes into food, listing of foods. And these are things that people absolutely take for granted. And the idea that if they are simply turned off, manufacturers will carry on respecting the law even if they're no longer required to, is, I'm afraid, for the birds, because of course all businesses need to try and cut costs. And they will not necessarily comply with high standards in the absence of having legislation telling them to do so.